Nationally, child sexual abuse impacts 1 in 4 girls and 1 in 6 boys before the age of 18. Only 1 in 10 actually tell, and when they do, it could take decades. House Bill 771 is an amendment to current Georgia law which will extend the statute of limitations on civil prosecution against child sex offenders. Statute of limitations is the maximum amount of time given to file charges or file a civil lawsuit following injury or other grounds in which to file. The law in Georgia allows 5 years for civil action past the victim's 18th birthday. This amendment, as written now, would allow 10 years. Childhood exposure to abuse and neglect can cause many short and long-term medical and psychological problems. These problems can include alcoholism, drug abuse, smoking, depression, suicide attempts, and adolescent pregnancy. As a society, we are all affected and must stop this cycle of abuse by exposing the abusers. House Bill 771 can help do this. But not all agree. Those working in law enforcement may see this amendment as creating problems within our justice system. As time passes, memory fades, witnesses die, and evidence is lost. Some may be unjustly accused. Our legal system will get clogged with unnecessary lawsuits and cost our taxpayers money. Communities, municipalities, churches, schools, athletic programs, and long-standing institutions could see themselves vulnerable to costly prosecutions. This bill will offer survivors of childhood sexual abuse special rights not given to other crime sufferers. This is the opportunity to extend the time limit of prosecution. Child abuse advocates do not feel this bill goes far enough. They feel there should be no limitation at all. Those that are poor and mentally unstable may never see their day in court. The hopes of a monetary judgment could make it easier, but attorney's fees and court costs, not to mention the time spent on the trial, could be intimidating and completely unrealistic for many. In Georgia, civil attorneys can potentially take 25 to 40% of the final judgment. But how much judgment could be rewarded? The system has not been tested enough. And will the passing of time affect the amount of the judgment? Special interest groups such as the Archdiocese of Atlanta, insurance companies, do not like to hear that statute of limitations may be extended or even eliminated. The idea that civil charges can be brought up at any time is scary to them. It opens up an endless time for prosecution and a huge potential of lost money. Not to mention a huge embarrassment to these groups, which will take time and more money to change their broken image. We have seen this happen with the Catholic Church and more recently at Penn State with the conviction of Coach Sandusky. House Bill 771 would be an amendment to an existing law that reads in part, any civil action for recovery of damages suffered as a result of childhood sexual abuse shall be commenced within 5 years. This bill was originally intended to remove the statute of limitations altogether, but was changed while in committee to read 10 years. The sponsor of the bill is Republican Representative Jason Spencer. He was approached by some of his constituents who saw a gap in the law. There was an incident of child sexual abuse in the community where young boys were molested by their karate instructor. They came forward, but it was too late to prosecute. So an idea was formed to eliminate the statute of limitations. Many other representatives from both parties came on board to support the bill. The bill was assigned to the Judiciary Non-Civil Committee, and on February 26th of the session, it was favorably voted by substitute. This basically means that everyone was in favor, but they needed to change the writing a little. It went from eliminating statutes entirely to the 10 years. Spencer was unaware that some legislators went weak on their position because of pressure from the special interests. Apparently, co-sponsor Republican Rich Golick, chairman of the Non-Civil Committee, is also a lawyer for Allstate Insurance. Possible conflict of interest? You decide. It was never presented to the House for a vote, and as they say, the bill died. If re-elected, Spencer will try again to reintroduce the bill. Those who will be responsible for administering this law will be our law enforcement agencies and the judicial process through this Georgia court system. This will also include placing those convicted on a child predator list. sponsor of the bill, Jason Spencer, was instrumental in the proposed House Bill 771. The bill was originally intended to read no statute of limitations on civil sexual abuse cases, but the message got diluted due to the special interest. Spencer realized that he may have been unaware that there would be so much pressure from outside groups and turned his attention to other issues in his own re-election campaign. He did his best to attach it to another bill in a last attempt to push something through, but with a very short and busy session, he could not make it happen. He was disappointed, not only in himself, but with his co-sponsors. He really thought he could make a difference for the boys in his community that were abused by their karate instructor, and also for his wife, who is a childhood sexual abuse survivor herself. If he wins re-election, he will reintroduce the bill, but this time he will be ready for the pushback. He will align himself with child advocates and other survivors and write worthy legislation. He says he will turn to Marcy Hamilton for advice. Marcy is an expert on statute of limitations on civil trials for childhood sexual abuse. Mary Margaret Oliver, Democrat and representative from Decatur, my district, was a co-sponsor of the bill. She was unavailable to speak with me, but her chief of staff, Carol Stern, called me on the phone post-crossover day. He said Representative Oliver was approached by Spencer because he needed a co-sponsor with experience and those that took on other child welfare legislation. He didn't know too much about this bill and why it died, but he did say in the future, in order for Spencer to pass a successful piece of legislation, he would need it to be rewritten and possibly attach some new people to it. Another community stakeholder interviewed was Alan Fountain, a survivor of childhood sexual abuse and volunteer and executive director of advocacy group Truth Plus Answers Equals Power, TAP, as well as a member of the Georgia Families of Justice, which is a non-governmental agency comprised of citizens who lobby their support for statute of limitations justice reforms to protect against child sex abuse legal loopholes. He's a passionate advocate. Mr. Fountain shared with me his own story of sexual abuse from a serial predator in Thomaston, Georgia, where he grew up. He was abused from the age of 9 to the age of 16 by the coach of the youth athletic program. His abuse left him with post-traumatic stress disorder and has spent over 30 years and nearly $2 million on his own medical care in order to treat his symptoms which resulted from his traumatic experiences. Mr. Fountain has followed House Bill 771 and sees its challenges in getting passed because of power and money issues. Too many lobbyists and corrupt legislators. He says the bill protects the special interest groups too much. The last person interviewed was another survivor of childhood sexual abuse and wishes to remain anonymous. She wanted to tell her story to me because it was a way to help herself get through a difficult time and possibly help others. She was sexually abused by her mother's boyfriend when she was a young girl. Like many in her situation, she was afraid to come forward and tell anyone what happened. It wasn't until many years later that she shared her experience with her mother. She was angry with her and told her it was her fault. We talked about the proposed bill and how it would affect her. She feels it would be a great bill if it could eliminate the statute of limitations. She doesn't feel she could ever bring charges against her perpetrator. She feels it would be too hard on her and her family. The social issue being addressed in House Bill 771 is that there is not enough time provided to survivors of sexual abuse to be able to bring a civil case against their abuser. This is at the core of the NASW Code of Ethics. We must protect those who are in need and provide them with the tools to better their lives. We must also challenge social injustice by providing those affected with the additional time. By providing them a means of empowerment, we can enhance their self-worth and assist in creating people who can better contribute to society as a whole. I am not in favor of the bill as it reads today. I believe there is too much politics involved. There should not be two sides to this issue. The bill needs to become a solid piece of legislation that will protect all survivors of childhood sexual abuse.